Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this live legal educational content, and today may be the day I earn your subscription. For today's case, we are dealing with our ongoing coverage of SB 8, the Texas Heartbeat Abortion Bill. When we last left the action, we covered the United States initial complaint. Since then, many things have happened. We have not been able to cover it for a little while. In fact, the TRO was granted, and it's also been removed again by the Court of Appeals. So a lot's happened. We're like 5 things behind. But that's okay. We're just going to cover them in sequence anyway, so that we can learn from things. So when we last left the action, we did the United States initial complaint. And overall, my thoughts were that it raised a lot of very good issues. And Texas had some chances on the technical aspects of the procedural aspects of the bill, particularly on the severances portion with the, please rewrite our law for us sections, which were very creative. So the United States of America made a very good case, but but Texas also had some chances as well. So now we're going to see Texas's response to the TRO, their request that the TRO not be granted, which was granted and then ungranted by the Court of Appeals, but at least as far as we're concerned in our coverage, we haven't gone that far. So we're going to read this and see what we can learn from it. Let's get started with this. The court should deny the federal government's motion for a preliminary injunction and dismiss this case. Article 3 of the Constitution does not permit courts to hear a proceeding against the government in its sovereign capacity when the only judgment required is to settle the doubtful character of the legislation in question. Please take note of those last words in care, because if the only thing is to settle the doubtful doubtful question or the doubtful legislation, that doesn't create standing. But if something else is required, for example, an injunction, then that's not the same thing. So Texas is off to a bad start here by quoting a law that does not stand for the proposition that Texas wants to use it for. Disregarding this jurisdictional defect, the federal government seeks extraordinary relief, which it is technically extraordinary. All injunctions are extraordinary relief, so they're right there. An injunction against non-party private individuals and state judges without even identifying a cause of action. Congress has created numerous specific causes of action for the Attorney General, but not one that applies here. Congress has created causes of action for the Attorney General to enforce various constitutional rights as statutory rights under the Freedom of Access to Clinic Entrances Act, but Congress has never created a cause of action to enforce a constitutional right to an abortion. Instead, it's repeatedly refused to create a broader cause of action for the Attorney General. Not for nothing, but I think the Attorney General of the United States should have broad power to enforce the Constitution of the United States. That seems like good. I'm not sure that a specific congressional action is specifically required if what you're trying to do is enforce the Constitution of the United States. I'm not sure you need an additional thing from Congress of, by the way, the executive can also make sure that the law, which incidentally includes the Constitution, is actually in force. That seems odd. So, I'm not sold on that at all. The federal government asked the court to dispense with normal cause of action requirements based on unfounded fears that the Texas Heartbeat Bill will otherwise evade judicial review. It kind of will. Nothing could be further from the truth. The constitutionality of the Texas Heartbeat Act can be reviewed the same way all of state tort law is. State court defendants raise constitutional defendants before neutral judges sworn in to follow the U.S. Constitution and, if necessary, appeal to the Supreme Court. Yeah, but they can't get injunctions like they can in like everything else, which is an equitable remedy. So there's that. True, some abortion providers might prefer to be federal court plaintiffs rather than state court defendants. But that preference is not a constitutional right. This is odd to me. I think it should be a constitutional right. If the state is planning to interfere with your constitutional rights, shouldn't you be able to get vindication on the front end rather than just merely wait for them to come after you as a defense? So, it's also an issue Congress has already considered. The Attorney General has statutory causes of action to enforce certain 14th Amendment rights if he concludes the affected individuals are unable to initiate and maintain appropriate legal proceedings, which they can't. They can't initiate the proceedings, right? Because that's the whole problem. These abortion providers want to be federal court plaintiffs rather than state court defendants. You know what a defendant is? Not the person who initiates proceedings. So, but those causes of actions are limited to equal protection rights. Congress's detailed cause of action scheme precludes the Attorney General from bringing this suit to enforce constitutional rights to abortion. The federal government also asked its courts to disregard the standard limitations on injunctive relief, effectively conceding that an injunction against the state would be useless because the state does not enforce the law. The federal government seeks an injunction running against two groups of non-parties: private individuals who might bring heartbeat suits, which the U.S. government basically argues are public agents. Despite being private, they're public. They've been empowered by state law to enforce state law in ways that don't impact them, what we call a private attorney general. And state courts that might adjudicate those suits. Number two is much more promising. It might be very difficult to enjoin the courts because of Parte Young, which seems to suggest strongly against it. But enjoining the private parties, which really aren't private parties, they're really state actors, seems a little bit more promising. The court cannot decide that absent third parties are subject to an injunction without letting them be heard. An injunction against a state court would be a violation of the whole scheme of our government, citing Ex Parte Young. As to that, Texas definitely has a point. As the Fifth Circuit has recently held, it's absurd to contend there was a way to challenge an unfavorable state law is to sue state court judges who are bound to follow not only state law but U.S. constitutional law. That is trying to get an injunction against the judicial branch is, it doesn't seem like that can fly given the state of the law. What is worse, the federal government asked its courts to overcome all these hurdles in order to issue an effective injunction against a valid law. According to the federal government, abortion providers are chilled by prospect of future liability in state court. But on these facts, a preliminary injunction would not unchill the providers. Yes, it would. In light of a strong possibility that any preliminary injunction would eventually be stayed or reversed, allowing heartbeat suits in the state court to proceed, abortion providers would still face the prospect of future liability because they wrote the bill in such a way that a preliminary injunction would not be sufficient. So so in light of the strong possibility, any preliminary injunction. So they're kind of right, but they're more wrong. So the way the SB 8 is written, it definitely says that you can't rely on any judgment that is later reversed. So it is true that a TRO would itself not defeat SB 8. But the federal court can still go around that and be like, as a matter of law, there's immunity to that. And also the fact that there's the TRO as a logical place is an appropriate state place to start. So the TRO may not grant the abortion providers all the relief they want. I mean, it certainly doesn't, because they want a permanent injunction. But a TRO is a step along the way. So, yeah. Finally, the Texas Heartbeat Act is constitutional. Even if the federal government does not challenge the constitutionality of many of the provisions, which I suppose is true. Many of the provisions probably are constitutional. It's the ones that aren't that are decidedly a problem. No one disputes the constitutionality of requiring doctors to determine whether a woman's unborn child has a detectable heartbeat. I believe this is true. No one would contest that. Requiring the doctor to detect the heartbeat would not place an undue burden on the woman. It might be a little bit unnecessary, but it's not a burden. No one disputes the constitutionality of provisions of governing attorney's fees. Fair enough. The federal government's challenge is limited to provisions authorizing private parties of action, which is kind of the entire thing. It's only going after the private party's ability to bring lawsuits. Yes, you are correct, sir. That's a lot. The federal government raises no argument that Texas cannot authorize heartbeat suits for post-viability abortions. Correct. For post-viability abortions. You are 100% correct. Heartbeat or not, I mean, presumably having a heartbeat would be necessary for post-viability, so not detecting a heartbeat would suggest non-viability, but I digress. But under Casey versus Planned Parenthood, Texas is 100% correct. Post-viability abortions can be banned. Completely. That's Casey versus Planned Parenthood. Post-viability abortions, the government has the right to ban all post-viability abortions. Right. No one contests this under the current law. The pre-viability ones would be distinctly an issue that is definitely in play. In any event, the heartbeat bill cannot violate U.S. Supreme Court precedent because it incorporates the court's undue burden test as a defense, which is where Texas tries to get clever. And I recognize their cleverness. They're certainly trying. So maybe Texas has chances there. So far Texas has been, we finally got to an argument that kind of makes sense at the end of the introduction. They incorporate the undue burden test. Everything else has been BS so far. They can't sue the government in its sovereign capacity if all they're doing is trying to clarify what the law means. True, but that's not what they're trying to do. They can't go after the judges. Yes. The bill is legal in parts. They're only trying to stop the private party's cause of action. Yeah, that's, kind of, the linchpin of this whole thing. No one's contesting that Texas can't ban post-viability abortions. You are correct, sir. We finally got to an argument that at least passes the laugh test. We tried to incorporate the undue burden, so we can get to something that doesn't make us just laugh out loud. That's nice. In the end, the motion for a preliminary injunction presents a complex and novel antecedent procedural question. That's true, it is novel and complex, but that's one of the things courts do with their time, especially at trial court. Less so with appellate courts. So when the U.S. Supreme Court said, we're going to punt because this is complex, much more understandable. The U.S. Supreme Court doesn't really do law in the first instance. They let the lower courts take care of that law, and then they'll eventually reverse. But it's like, we're not ready for this because you guys haven't figured it out below, so we can agree or disagree with you. So it made a lot more sense. But here, this is a trial court trying to figure out, what does the law mean? So novel, complex, that's one of the things they pay trial courts for. Super fun. Okay, so now we have the standard for an injunction, which is the same for a temporary restraining order, the same for a preliminary injunction, and the same for a permanent injunction. It's the same four-part standard for all of them. They are viewed a little bit differently as a matter of practice, so the way the standard is evaluated is a little bit different, but the ultimate standard is the same. $5 from News Now Wyoming. How does a lawsuit under the law work with Hillary? If a woman who got an abortion can't be sued, her medical records are private and can't be deposed. I don't know the answer to that question. I don't know. I'm not an expert on medical privilege law in Texas, so I don't know the degree to which the doctor would be able to bring the patient records as is necessary to defend a lawsuit. I don't know the ethics rules well enough, but they might allow for it. They allow it for an attorney, incidentally. So, if an attorney gets sued, an attorney can break privilege to defend themselves in the lawsuit. So that might be true for medical cases too. So I don't know. Maybe it's okay. I don't know. This court should dismiss because it lacks subject matter jurisdiction. No. And because the federal government lacks a cause of action. The court should deny preliminary injunctive relief for additional reasons. They've not shown the Texas Heartbeat Bill is unconstitutional. Preliminary injunction would remedy the irreparable harm. Or the balance of equities and public interests favor the relief. This is not an Article 3 case or controversy. No federal court can hear a case to determine the constitutionality of a state the sovereign defendant is not enforcing. If that was the only thing that was going on, yes. The fact that private parties may rely on the statute in other litigation does not create a case or controversy against the sovereign. That is typically true. It wouldn't be true if the private party isn't really a private party, though. And that's part of the problem. It simply shows that other cases would be proper cases for deciding the constitutionality of the challenge statute. There is a holding. This is the holding of Muskrat versus United States, in which the Supreme Court considered a series of federal statutes affecting property rights of Indians or Native Americans. The first statute gave Indian property rights in certain tribal areas, including lands. Subsequent statutes reduced those rights. Congress created a new cause of action allowing Indians injured by those statutes to sue the federal government to determine the validity. So Congress said, you have the right to sue us in order to determine if it's valid. But that's not a case or controversy, so Congress can't do that. The Indian plaintiffs filed suit just as Congress, because they didn't give them the power to enjoin. If they had had the power to enjoin the statute, that wouldn't be nearly the power to declare if the law is wrong. Those are two different things. Like, it's the difference between declaratory relief and injunctive relief. And incidentally, declaratory relief has been expounded by statute. So at the time, there was no Declaratory Judgment Act. It didn't exist yet. It exists now. So now they can do declaratory stuff because it's part of the law now. There's no doubt this challenge statutes injured plaintiff property interests. Those statutes attempt to increase or extend restrictions upon alienation, which is the right to give up something when you alienate it from yourself, encumbrance, or right to lease, and increase the number of persons entitled to share in distribution of lands and funds. Nevertheless, the Supreme Court held that this was not a case or controversy to which, under the Constitution, judicial power alone extends. The federal government, though made a defendant, which also, incidentally, is different than when the federal government is a plaintiff, and there's definitely case law for that, made the defendant had no interest adverse to the claimants. The plaintiffs were not demanding government cease some enforcement. They wanted to determine the constitutionality of the legislation, which they can't do unless there's some sort of conflict, which there is here. Of course, the court was willing to hear subsequent suits involving private parties, and incidentally, there's one of those going on now, too, as well. The question involved in this proceeding to the validity of legislation may arise in suits between individuals, and when they do, are properly before this court for consideration, they, of course, must be determined in the exercise of the judicial function. But interest in more quickly defining the constitutionality of the legislation as a naked thing could not outweigh the Article 3 jurisdiction. This is dumb. I'm just skipping the rest of this meek rat analysis. Blah, blah, blah. Skip the rest of that because the case doesn't stand for the proposition they're citing it for, so I'll just ignore it. Any injunction must explain who must act or refrain from acting. After all, an injunction is a judicial process or a mandate operating in personam, that is, against a person, as opposed to in rem, like against a property. Only people can do things. And therefore must direct conduct of a particular actor. You have to tell a person whether or not to do things. You can't tell things whether or not to do things. Yeah. The federal government is trying to avoid this by asking for relief against the state of Texas. Of course, when the shoe is on the other foot, the federal government insists any injunction entered against the United States shall specify the federal officer or officers responsible for compliance. Again, the case law is a little bit different. The case law is a little bit different when it is the United States as defendant versus the United States as plaintiff. When you sue I'll just tell you the difference, by the way. It's not that hard. When you sue the United States as the plaintiff, the United States as such, right? The United States as such, as a plaintiff, you can't do that because of sovereign immunity. You can only do that if Congress says you can. And Congress, incidentally, has passed a law saying where you can. So it's not that you can't ever do it, but you can only do it if Congress says so. So the United States court, the United States federal government enjoys sovereign immunity before the federal courts. And because of the supremacy clause of the Constitution, which says the federal government and its Constitution are supreme to state governments and its constitutions, the federal government is also immune before state courts. So you can't sue the U.S. government in a state court. You can only sue the U.S. government in a federal court if the U.S. government says you can. Okay, how about the other way around? All right, so now the United States government wants to sue a state court. Well, or sue a state. Well, they might have a problem in a state court, right? U.S. government versus Texas, USA versus Texas. If they file that in a state court, they're state courts. And as we all know from anti-commandeering doctrine, like Prince versus United States, for example, we know the United States government cannot force the state government apparatuses to do stuff. Yeah, for anti-commandeering. So the state judicial branch would be well within its power to say, you know what, federal government, go away. You can't sue our government in our own courts. And they would be right. However, if the United States wants to sue the state of Texas in federal court, well, that's a whole different set of circumstances now, isn't it? Because, yeah, the state is sovereign, but then again, we have this whole federalism thing, and the U.S. government has the power to sue a state implicitly to have its own laws recognized. The United States government has the implicit right to seek redress in its own courts. There's a U.S. Supreme Court case that says that, by the way. I'm not just making that up. So that's why the posture is not the same as if it's Texas versus the United States, or Texas or United States versus Texas. That may or may not be fair, but it's the law. Without clarity about who is supposed to do what, a defendant cannot ensure compliance with the injunction. That is why every order granting injunction must state its terms specifically and describe in detail the act or acts restrained or required. In this case, any injunction would have to specify which Texas officials are supposed to refrain from enforcing the law. The federal government offers only two possibilities: private individuals or the state courts that adjudicate. The court cannot order relief against either group. I agree as to the second, not so sure about the first. The federal courts sure have the power to enjoin private individuals. Now, as I'm sure they're going to argue, like, the private individuals are normally entitled to notice, but here the argument is that they're not really private individuals. They're really state officials. So, yeah. $5 from News Now Wyoming. Since this injunction is against the Texas courts to not take the cases, do the feds carry a stick to stop that? No, it seems like not. We're getting into that analysis. We haven't gone that far, but can the U.S. government, through federal courts, get an injunction against state courts? The answer seems to be no. There's a case called Parte Young for that. You can get and you can't get an injunction against the legislature either, incidentally. So you can't stop the legislature from passing law, and you can't stop the courts from adjudicating the law. But what you can do under Ex Parte Young is you can stop the executive branch from enforcing it. So in order for this to make sense, you have to say that the private individuals are part of the executive branch, which they can be. They don't have to be members of the executive branch for all purposes, right? I mean, any executive official of any kind can be an executive official for whatever purposes the law defines. Like, it doesn't have to be for all purposes. It can be for very limited purposes. But they're still a state official for those purposes. So, yeah, an injunction against state courts doesn't seem like it's going to fly. Ex Parte Young, an injunction against the legislature doesn't seem like it's going to fly. But an injunction against all private people who aren't really private people, that might work. The federal government would have this court enjoin private third parties from filing suits in state court, but they are not parties. An injunction is overbroad if it attempts to affect rights between a party and others who are not parties. This also, incidentally, was a point I made notice of earlier, that like every private person, and because it's unlimited, it's every private person in the world. So you'd have to give notice to 7 billion people, I guess. In an effort to avoid the due process problems with enjoining non-parties, the federal government argues that private plaintiffs are either agents of the state or in active concert with the state, and thus bound by judgment. Yeah, they're agents of the state. That's the argument. That question is not properly before the court. Well, it kind of is. But in any event, private would-be plaintiffs are not connected to the state and therefore cannot be enjoined. First, third parties have a right to be heard on whether they're agents or in active concert. So the court cannot decide the question without their participation. Okay. Even where a party and non-party are obviously related, as with a parent and subsidy corporation, the non-party cannot be named in an injunction without first being heard. In Zenith, the party stipulated for the purposes of litigation, its parent will be considered one and the same company. Relying on the stipulation, the district court issued an injunction against HRI, which was a party, as well as whatever, which was not. The Supreme Court vacated the judgment against the subsidiary. Although injunctions can bind those persons in active concert or participation with the parties, it was an error to enter the injunction against the other company without having made this determination in a proceeding to which it was a party. That makes sense as an argument. You can't enjoin these private parties without them being participating, and you certainly haven't given notice to the entire world. Whether a particular person or firm is among parties, officers, agents, service employees, and attorneys, or other persons in active concert or participation with them, is a decision that may be made only after the person in question is given notice and an opportunity to be heard. Interesting. Now, what's really interesting on this, on like a legal level, is this is a weird situation because all the private people are in the same exact posture legally. Like, it's not a subsidiary of a company, and you can have different kinds of subsidiaries, right? So you can have wholly owned subsidiaries, partially owned subsidiaries, all kinds of weird relationships. So it's not like they're all in the same posture. And even where they're subsidiaries, they might be doing different, even if they're fully owned, they might be doing different kinds of business. So one could be a fast food restaurant, one could be, chemical supplies, to borrow from Breaking Bad. Right, even if they're subsidiaries. So the logic wouldn't necessarily flow from one to the other. But in this case, all the subsidiaries of the state, which is literally every person in the world, the way SB 8 is written, they're all in the same posture. There's nothing different about them in terms that would impact the legal analysis. My defense would be the exact same defense as any other random person's. So that's an interesting aspect to this in terms of the notice issues. Thus, an injunction purporting to bind non-parties would be ineffective. A court cannot lawfully enjoin the world at large, no matter how broadly it words its decree. If it assumes to do so, the decree is ineffectual, and the persons enjoined are free to ignore it. Okay. Oh, and apparently this was decided by Judge Hand, who is a badass. Judge Learned Hand. Total badass. Second, the federal government asserts in a footnote and without any supporting citation that individuals who file suit under SB 8 should be considered agents of the state. The federal government has forfeited this argument because it's not adequately briefed it. In a TRO? If it were properly presented, it'd be wrong. Private parties are plainly not agents of the state, even when they have an interest in defending the constitutionality of state law. A private plaintiff bringing a heartbeat suit cannot be Texas's agent because Texas lacks the right to control the conduct of that private plaintiff. No, that doesn't make sense. Just because the Texas executive has said, hands off, it doesn't make them not your agent. It would be like me giving someone an irrevocable agency, which I'm not even sure that's technically possible, but bear with me. And like me, going, or maybe it'd be like me giving someone an agency and then locking myself in a cabin in the woods or something where no one knows where to find me. And be like, oh, I had no ability to control him. It's like, only because you put yourself in that position, So, learned hand. Learn. L-E-A-R-N. L-E-A-R-N-E-D. Learned hand. L-E-A-R-N-E-D. Learned hand. And let's judge hand to you. Third, private parties are not in active concert with the state. The Fifth Circuit rejected the federal government theory in Texas versus Department of Labor. In that case, the Department of Labor was enjoined from enforcing one of its rules regulating overtime. The rule itself, however, remained in effect, and a private party sought to enforce the rule against the employee. The district court held that had enjoined the DOL had held the employee in contempt, but the Fifth Circuit reversed. DOL could not have adequately represented the company's interests because there's no legal relationship making DOL accountable to the employee. Further, DOL could not adequately represent private employees because the Fair Labor Standards Act explicitly establishes a private right of action, allowing an employee to sue. The Fifth Circuit expressly rejected the theory that DOL represents every worker's interest. Yeah, that kind of makes sense. Yeah. So as to bind every worker. Okay, so we have a case involving Department of Labor. Department of Labor tries to say, basically, that we're a stand-in for every single employee. And the court apparently rejected that. Like, no, you can't quite do that. So the argument maybe is here the same. Yeah, maybe. So too here, Texas has no relationship with absent third parties, and Texas does not represent the interest of those who would bring private causes of actions. Well, yeah. Relatedly, the Texas Attorney General is generally not authorized to represent private individuals. That's true. But then again, that kind of is begging the entire question about whether or not they are private individuals. In essence, the rule prevents defendants from nullifying a decree by carrying out prohibited acts through aiders and abettors. But even the federal government does not contend that private individuals are Texas's aiders and abettors. If a private individual files a heartbeat lawsuit in court, the individual is not helped to bring about the act of a party, which is the only thing the court has the power to forbid. I'm not sure about that one. In the act, the federal government effectively asks this court to enjoin all persons to whom notice of the order of injunction should come. But such an overbroad injunction would clearly be erroneous. The court cannot make punishable as contempt by a person who act independently and whose rights have not been adjudicated according to the law. That's a pretty good argument, actually. That's a pretty good argument. An argument that I noted earlier in my coverage of this case, which is incidentally why even this lawsuit may not be the one that carries the day. Texas is much better off than when it was private party versus private party. That was a total non-starter for a whole bunch of reasons. Texas versus the United States is better. We've discussed those reasons too, but it might, because of the way the mechanisms are set up, and it's probably correct. It might very well be correct, and this might be the basis of the Court of Appeals decision, which we'll come to in 4 videos from now. It's going to take a while. But it might be that, yeah, these people need to be given notice, and you haven't done that, which also, incidentally, is impossible. So then we're left with the Texas abortion doctor who said, "Come at me, bro." And people came at him. So now you're avoiding all those problems, right? You have people who are actually in jeopardy. You have people who actually are plaintiffs, and you can adjudicate it. So that makes a lot more sense. So, yeah. The federal government invites the court to specify an injunction runs to the state judiciary. But that will be a violation of the scheme of our government, citing Ex Parte Young. Ex Parte Young is definitely a problem for the federal government here. Even if it's recognized as a federal court's power to enjoin state executive officials from commencing suit, the Supreme Court cautioned that such authority does not include the power to restrain a court from acting in a case brought before it. Yep. The difference between the power to enjoin an individual from doing things and the power to enjoin the courts from proceeding in their own way in exercise of jurisdiction is plain, and no power to do the latter because of the power of the former. The Fifth Circuit has long rejected lawsuits against state judges. The case or controversy requirement of the Constitution requires a plaintiff to show that he and defendants have adverse legal interests. But the requirement of a judiciable controversy is not satisfied where a judge acts in his adjudicative capacity. Preach that. Preach that. Now, we've discussed this barrier, we've discussed this boundary before, but we might as well mention it again, right? It is possible for courts to not act in a purely adjudicative capacity. They have some power beyond that, most notably, perhaps, to other lawyers, in which case they're the regulatory body. The judiciary is the regulatory body instead of the executive, because it's the judicial branch. So they're the regulatory body over all the lawyers. So when they are regulating all the lawyers, that's not adjudication. That's regulation. It's regulation by the judicial branch. That's a thing. Yeah. So it's possible. So if you have that kind of situation, you can go after the judges because they're not acting adjudicatively. They're acting as an executive. The separation of powers between executive, legislative, and judicial is not absolute. Even in the federal Constitution, you can find little bits of all branches of power within any branch of power. Like there's a little bit of judicial and legislative in the president and so forth and so on, right? They're not completely separate. There's little bits of it. And this would be one of those times, like a little bit of executive power in the judicial branch, deal. Have a safe trip, Stephanie, as always. Confirming that the rule applies here, the Fifth Circuit, and I'm hoping and looking forward to seeing you very much in the near future, since you're coming to my turf. That'll be awesome. Anyways, News Now Wyoming says, I despise absolute immunity. If the opposing party bribes the judge, you cannot sue the judge. You can sue the judge for the bribe. That is not within the judge's power. Yeah, you can sue the absolute immunity. Absolute immunity only extends to adjudicative acts. Accepting a bribe is not an adjudicative act. Yeah, absolute immunity does not extend to the bribe. You can sue the judge for the bribe. Yeah, that's fine. In fact, that's happened. And judges have gone to jail for the bribe. Perhaps, I don't know if it's most notably, but definitely notably, there was, I think, a couple judges who went to jail in Pennsylvania. I know at least one, and I think it might have been a couple who went to jail for accepting bribes in child custody cases. No, it wasn't child custody. It was juvenile detention cases. It was sending the kids to jail. Yeah, there were a couple judges. There was one or more judges in Pennsylvania who were literally doing cash for jail. Give me money, and I will send the kids to jail. That absolute immunity doesn't go that far. No. No. Oh yeah. Yeah, no, yeah. Stephanie needs to visit the Whiskey Tribe guys for sure. That's in my neighborhood of Austin. So when she comes to Austin, we'll definitely do the Whiskey Tribe thing. So sure, that'll be great. And incidentally, News Now Wyoming, that's not actually quite correct either. So I'll just keep correcting things. Yeah, News Now Wyoming, absolute immunity does extend to criminal. Qualified immunity doesn't. All right, so qualified immunity extends to civil, but not criminal. Absolute immunity extends to both civil and criminal. But it's not all civil and all criminal in every context, right? Just to make it completely plain, the difference, right? If a judge wasn't on the bench and just walking down the street and just punches a guy in the face, do you really think the judge can't be prosecuted for that? Of course not, right? The judge is not exhibiting any judicial power. They're just walking down the street, and they get into a bar fight. Yeah, the judge can be prosecuted for the bar fight. So the absolute immunity does extend to criminal, but it only extends to criminal in so much as it relates to the judicial powers. Once again, accepting bribe is not one of those. Confirming this rule applies here, the Fifth Circuit held that plaintiffs challenging a heartbeat bill were not adverse to state judges. When acting in their adjudicative capacity, judges are disinterested neutrals who lack a personal interest in the outcome. It is absurd to contend, as plaintiffs do, the way they challenge an unfavorable state law is to sue state court judges, who are not only bound to follow the law, but the U.S. Constitution as well. In light of that obligation, neither the federal government nor any potential state court defendant can be shown a certainly impending injury traceable to the courts. Whether any given state court will find the defendant liable is a matter of pure speculation. If a state court defendant presented a meritorious constitutional defense, the state judge would be duty-bound to dismiss the case. The federal government presents no evidence suggesting state judges will fail to do so. Moreover, in light of state judges' obligation not to prejudge cases, each judge lacks an adverse interest necessary to support federal jurisdiction, even if at some time later the judge might rule as the federal government fears. The other federal courts that consider this question have reached the same conclusion. As Justice Breyer wrote when he was still Judge Breyer, at least ordinarily, no case or controversy exists between a judge who adjudicates claims under a statute and a litigant who attacks the constitutionality of the statute. The Supreme Court and the Fifth Circuit have approved this as well. Similarly, the 11th Circuit affirmed the denial of preliminary injunction against state judge. 699 from Emily Kennelly, I am here in British Canadian Canada. Are they trying to take a woman's right to an abortion? In Texas? Yes, they certainly are. In Madras, the court held that state judges do not have an adverse interest to the plaintiffs in determination of the constitutionality of a state statute because it was a judicial officer bound to decide the issue according to law as they find it. The critical difference preventing federal judicial jurisdiction I'll skip that. Effectively conceding the impropriety of suing a judge directly, the federal government suggests it can sue the judge indirectly. Even if a suit directly against a judge could not proceed, this is a suit against Texas, its officers, employees, and agents. Yeah. Under Muskrat, though, a judgment against the sovereign does not bind the sovereign courts in future litigation. Muskrat is so off point here. There's better cases for this proposition. The Supreme Court explained the proceeding against the government in sovereign capacity to determine constitutionality of legislation would not resolve for private parties when actual litigation brings to the court the question of the legislation. That's, again, we can cite better cases than this. What's going on in my chat now here? What's Peter saying? News Now Wyoming says you should check out Mireless versus Waco. Absolute immunity was given to the judge even though he told the cops to rough up the arrestee. Well, I mean, okay, so you found a case. First of all, we could go into the exact issues about whether the judge was or was not acting in their judicial role at the time. So we could really get into the technical minutia of the case about whether the judge said it in a capacity or whatever, but, you know, let's not diverge ourselves with an analysis of a completely different case. Let's just accept the proposition, please, that absolute immunity does not extend to criminal things that are not related to the adjudicative role. Okay? And I bet $100 That case doesn't say anything different about it. It's probably a question about whether or not he said it in part of the adjudicative role without even reading it. In any event, the federal government gets things precisely backwards. There are more hurdles, not fewer, to enjoining those who are not named as defendants. As explained above, the court cannot pre-decide. Judicial officials are within the scope of the rule, and therefore be subject to any injunction when they're not parties. I'm less sympathetic to this with respect to the judges. But on this argument, right? But ex parte Young gets you where you need to be. So you don't need to cite this proposition. We're having a conversation across multiple streams. Just ignore us. You'll be confused without context. Just be nice to Stephanie. Or I will whack you with a hammer. And not necessarily a ban hammer. The federal government next proposes that even if the court cannot enjoin state judges, it could enjoin the state clerks. The federal government cannot join any part of the state judiciary. I agree. The Supreme Court is self-recognized contention. The federal court would have power to prevent any investigation or actions by a grand jury, because a grand jury is part of the machinery of the criminal court. Yeah, that's right. Grand juries are part of the judicial branch. The Fifth Circuit also rejected the federal government's theory that just a few weeks ago. Hold on. The federal government's argument does nothing to dispel the grave doubts that the clerks of various courts have real interest in defending actions taken by courts because their job is primarily ministerial. Yeah, the clerks are ministerial. We're talking about the people who file things at this point. Their role is ministerial. They see the paperwork, they make sure the paperwork is correct, they file the paperwork. They have no judgment, right? They just see, is the forms properly set out? If so, we'll file it no matter what crap it is. That's the deal. At common law, there's no such thing as an injunction against a judge. Injunctive relief was an equitable remedy that could be awarded by the chancellor only against parties in proceedings before other courts. Yeah, that makes sense. Injunctions come from the judiciary. Going to the judiciary is kind of odd. That this case itself contemplated in relief against a judge does not undermine this case law on this relief. Confirming these limits on injunctive relief are related limits on the writ of prohibition. Historically, writ of prohibition has been used to control inferior courts. But federal courts cannot issue the writ to control state courts because the state courts are not inferior courts. When we say inferior courts, we mean lower courts, right? The Court of Appeals for the Federal Circuit is inferior to the U.S. Supreme Court. The District Court for the U.S. District Court of D.C. is inferior to the Court of Appeals for the D.C. Circuit. The Texas Supreme Court is not inferior to the U.S. District Court. They are different branches of judiciary. In modern practice, courts do not usually distinguish between mandamus and prohibition. They're the exact same thing. Yeah, you must do something, you must stop from doing something. Federal courts have no general power to issue writ of mandamus to state courts and their judicial officers in performance of their duties, where mandamus is the only remedy sought. Yeah, you can't do that. You can't issue a writ of mandamus to a state court. You can overrule them, but that's different. You can't make them rule differently in the first instance. Yeah. Unless, of course, you're the Texas Supreme Court and issuing a lower state court. Then you can do that because you're part of the same system, right? The Texas Supreme Court can issue a writ of mandamus. The district court cannot. The federal courts are without power to issue writs of mandamus to direct state courts or judicial officers in the performance of their duties. When federal courts consider prohibition separately from mandamus, they still refuse to issue writs of prohibition to state courts. Prohibition is not an appropriate remedy to control jurisdiction of other non-subordinate courts. The Texas court system is not subordinate to the federal court system. Thus, a federal district court cannot issue a writ to a state court. Against all this authority, the federal government relies on Shelley v. Kraemer. But Shelley only found state action only after final judgment or otherwise dispositive order on the merits had been rendered, not in the mere adjudication of the case. Shelley cannot support a claim for injunctive relief. Shelley's procedural posture illustrates how a review of state court action is supposed to work. The Supreme Court grants certiorari to review the judgments of two state Supreme Courts that adjudicate the rights. Even Shelley does not contemplate injunction. Yeah, the U.S. Supreme Court can take cases from state courts when there are federal issues at play. And to the extent there are federal issues at play, they can reverse them. The federal government is not injured. The federal government has no apparent interest in challenging the act until the Supreme Court denied private plaintiffs' motion for injunction. It now forthright argues that judicial obstacles to the ability of women and providers to sue their rights justify its decision to sue Texas. That's fatal to standing because settled doctrine holds a sovereign plaintiff lacks standing, where it's merely litigating as a volunteer the personal claims of its citizens. I'm not really sure that's exactly what's happening here. The federal government claims that parent parentis standing applies, which no. That's basically where the government acts as the parents. No. But misapplies the doctrine, relying on precedent authorizing states to sue as parent parentis under some occasions. The federal government assumes it does. It does not. Yeah, the federal government doesn't have that power. A suit purportedly to enforce, purportedly to protect constitutional rights of women in Texas cannot rest on parent parentis standing. I think they're right. A parent parentis cannot step in to represent the interests of particular citizens for whatever reason cannot represent themselves. In fact, if nothing more than that is involved, if the state is only a nominal party without real interests of its own, then it will not have standing under parent parentis doctrine. Texas is making a lot of sense here. The Supreme Court has said that states can support parent parentis standing based on their quasi-sovereign interest in the health and well-being, both physical and economic, of residents. And quasi-sovereign interest is not being discriminatorily denied its rightful status within the federal system. The states have broad authority to enact legislation for the public good. Yeah, so basically this is just the idea that the states alone have police power. And so the police, therefore, have the power to sue in parent parentis because they have police power. The federal government does not have police power, so they can't do that. It makes logical sense. But the federal government does not have this authority. Unlike the states, it does not possess police power. Right. The United States government does not possess police power. That's correct. True, the Congress has interest in enforcement of the 14th Amendment, but it's not giving the U.S. government authority to bring this parent parentis suit about abortion rights. On the contrary, it's implicitly prohibited such suits by creating a much more limited parent parentis regime for abortion rights. The Freedom of Access to Clinic Entrance Acts authorizes the Attorney General of a state to commence civil action in the name of the state as parent parentis on behalf of natural persons regarding certain rights. The federal government has not pointed to any similar parent parentis statute authorizing it to sue. Even if the federal government could bring parent parentis action based on general health of Texas citizens, it does not clearly show the Texas Heartbeat Act is hazardous to women's health. Pregnancy is not an illness. It being an illness or not, I'm not necessarily sure means it's not health related. It's a bit, Indeed, in channeling abortions that might have been preferred later in a woman's pregnancy to earlier stages, the Texas Heartbeat Abortion Bill makes abortion safer. The earlier in pregnancy the abortion is done, the safer. Yeah, but we learned from Mama Dr. Jones recently, and her analysis seems right. on the biological aspects, we learned from Mom and Dr. Jones that basically no woman would know that she's pregnant before this heartbeat occurs, unless she's actively monitoring it, like hypervigilantly. And the only people who would be doing that are people who are trying to get pregnant. So as a practical matter, women wouldn't know if they're pregnant at the time. So yeah, that's, given what she said, that seems, right on the money. Finally, the federal government transport effort to overcome sovereign immunity problems that plague private challenges demonstrates the incompatibility of parent parental standing. As Justice Brennan explained, when one state brings a suit, excuse me, Noli D also raises the issue that I probably should have thought of automatically, but yeah, because it's illness doesn't mean it's not healthcare, and yeah, I mean, if non-health, that would like preclude like all sorts of care towards the baby that were non-illness related, by a doctor, which seems odd. That seems very odd. The federal government lacks a sovereign industry. The federal government also claimed a sovereign interest in making sure states do not violate the Constitution. But there is not an interest that can support standing. True, the Supreme Court has recognized sovereign interest in the exercise of sovereign power over individuals and entities within a relevant jurisdiction that involves the power to create and enforce a legal code. But the Constitution is not a legal code. What? The Constitution is not a legal code created by the federal government. Oh, I guess that's technically correct. Okay. Yes, technically correct. Technically correct is the best kind of correct. Yes, the federal Constitution was not created by the federal government. It's the other way around. So, yes, sure. Yeah. On the contrary, the federal government was created by the Constitution and the states, not the federal government that created the Constitution. Yes, sure. Again, although the Constitution gives Congress the power to enforce the 14th Amendment through appropriate legislation, Congress denied the executive branch any authority to enforce the right of abortion under the 14th Amendment. Meh. For these reasons, the federal government does not have sovereign interest that could support standing. The federal government cites a case called In Re Debs, but misunderstands the case. That case explains the federal government, like any other party, can bring any lawsuit in which it has a proprietary interest. The federal government has such an interest in the mails, so it has standing to sue. Okay. Yeah, because the Constitution gives explicitly the power of the federal government to create postal roads, which, of course, logically extends to the mail full stop. The Supreme Court also pointed to a second basis for standing. The Supreme Court indicated the following in dicta. Every government entrusted by the very terms of its being with powers and duties to be exercised and discharged for general welfare has the right to apply its own courts for any proper assistance in the exercise of the one and discharge of the other, and has no sufficient answer to its appeal to one of those courts that has no pecuniary interest. The obligations which it is under to promote the interest at all and prevent the wrongdoing of one resulted in injury to the general welfare is so often of itself incentive to give standing in court. This interference with commerce theory of standing turned out on the fact the national government given by the constitutional power to regulate interstate commerce has by express statute assumed jurisdiction over such commerce over the railroads. That meant the federal government was charged with keeping those highways of interstate commerce free from obstruction, for always been recognized as one of the powers and duties to remove obstructions from the highways under its control. That was the duty of the discharge which gave the federal government standing to seek proper assistance. Standing under this requires the federal government to demonstrate a well-defined statutory interest in the public at large. An interest in a generic sense is not enough. The court specified that noted the duty on which standing of the United States arose, not simply from grant of power to regulate commerce, but from congressional action expressly assuming and implementing. Okay. So I do like this thread of argument from Texas, and as I read more and more, it becomes more and more convincing. So, that's probably a good thing. Texas writes stuff, and I'm reading it, I'm like, yeah, that kind of makes sense. And as I read more of it, I'm like, yeah, that makes even more sense. So, yeah, the federal government might have a problem here on standing because they can't do parent parente standing. I agree. And they can't sue just on sort of a naked, abstract idea that the federal rights are being impugned. They have to point to something more specific, like, some power. So they'd have to point to, like, for example, they have to point to a federal statute that's being impeded, which they did in part, which is also, like, the Texas hasn't gone that far. And I also said that and Texas hasn't so far addressed it, and I don't know if they will in this, but even in the lawsuit, in the initial complaint, I said, yeah, the Texas cannot interfere with the federal government. It can't inhibit them. And they made some causes of actions along those lines. So to the extent that Texas is trying to interfere with, say, the Bureau of Prisons, or trying to interfere with whatever, it's a non-starter. So if they can point to a specific statute like they did in those examples, they have a cause of action. But they can't just sue on behalf of citizens in the abstract, and they can't just sue for violations of the Constitution in the abstract. They have to find something more specific, and Congress hasn't given anything more specific. So this argument makes a lot more sense. That makes a lot more sense. It's a reasonable, lucid challenge to the standing issues of the federal government. So sure, the federal government has the power to sue in its own courts, but like everyone else, that's like me saying I have the power to sue in court. I mean, it's a little bit like it, not exactly like it, but still. Yeah, saying the federal government can sue in court is a little bit like saying I can sue in court. That doesn't necessarily in and of itself give standing. It's just saying it's a thing that's possible. So to find something standing, you need to find a harm to the United States. So interference with a statute, interference with something that is regulated and run by the federal government, for example, the postal roads, or for example, the inland waterways, or for example, the railroads, or other federal statute, but nothing in the abstract. So Texas's arguments here for standing make a lot of sense to me. In this case, however, the federal government has not, by express statute, assumed jurisdiction over these abortions. The only federal government statute cited partial birth abortions, which Congress did ban. And states can ban also, of course. Indeed, under the Supreme Court's Commerce Clause jurisprudence, there's a serious question whether Congress even has the power to protect all post-heartbeat abortions without some further jurisdictional hook. All right. Let alone the executive branch unilateral's ability to sue to protect those abortions based on interstate commerce. Yeah, this is fine. Like, the federal government has the power to regulate interstate commerce, or more specifically, Congress has the power to regulate interstate commerce because it's part of Congress's power. Congress has the power to regulate interstate commerce. Damn you, Wickard. But Congress still has to regulate interstate commerce. So if they haven't, you might have a problem. So, yeah. Incidentally, another state could try to argue, like Oklahoma could try to sue Texas under some sort of dormant Commerce Clause theory, which would be kind of hilarious, because then you'd have original jurisdiction in the U.S. Supreme Court case, because it would be Oklahoma versus Texas, right? So, like, Oklahoma could give that a shot. Let's sue Texas under dormant Commerce Clause and see if the U.S. Supreme Court wants to take original jurisdiction on that bad boy. That could be fun. I use the word fun loosely, by the way. The federal government lacks a cause of action. Relatedly, the federal government also does not have a cause of action. The federal government must, of course, may sue a state in federal court under a valid cause of action, but it must have a cause of action. The federal government's sovereign status does not change this. When a state, as plaintiff, involves the aid of court, it is not exempt from the rules applicable to ordinary suits. It must establish the case of equitable cognizance and a right to particular relief demanded. For this reason, the federal government must establish a right of action by some statute. The federal government does not appear to rely on any constitutional or statutory cause of action. The Constitution does not create causes of action at all. It instead empowers Congress to pass legislation. Fair. The two constitutional provisions at issue, the Supremacy Clause and Due Process Clause, are not exceptions. The Supremacy Clause certainly does not create a cause of action unto itself. It is silent regarding who may enforce laws in court and under what circumstances. The same goes for due process. The federal government also disclaims any effort to identify a statutory cause. Although Congress has authorized suits by other types of plaintiffs to enforce the 14th Amendment against other types of defendants and authorized the federal government to enforce certain rights and statutory rights, no statute confers a cause of action for the federal government to file suit. That's a pretty good argument, actually. I have to give it to Texas because their standing argument's pretty good. Yeah, their standing argument looks pretty good. The federal government has not identified a specific common law or equitable cause of action that could support this. Ask for an injunction, but an injunction is not a cause of action. That's true, it's not. An injunction is what you want the court to do about it. A cause of action is what did they do that was bad? That's a cause of action. An injunction is, here's what I want you to do about it. I want you to stop it from happening. But you first have to identify the bad thing you want to stop. John, that's too Matt, as we remember, the state governments don't have to help. So I don't think the mere increase of cost by the state taking something away is probably not sufficient. Other courts agree. In Philadelphia, the Third Circuit considered whether the United States has implied authority to sue a city and its officials for an injunction against violations of the 14th Amendment. Although almost every court has had the opportunity to pass on the question, has agreed the United States may not sue to enjoin violations of individuals' 14th Amendment rights without specific statutory authority. This sounds really, really good. That precedent is consistent with the three separate refusals of Congress to grant the Attorney General authority and wide shared understanding authority does not exist. Yeah, this argument makes a lot more sense. I think Texas, this seems like a very strong rebuttal to the U.S. government's argument. I think Texas has generally characterized the United States argument correctly, and these all seem like really good rebuttals. So when we get to the United States' response to this, which we'll get in 2 videos, I think, then it'll be interesting to see how they counter this because it looks really, really good. The federal government attempts to distinguish this on the ground that's exceptional. But the federal government seems to think often it's exceptional. That's definitely true. Nor is there an equitable cause of action for the federal government supremacy claim. No precedent holds that considerations of federal supremacy can create cause of action where none exists under a state law or otherwise. In fact, the Supreme Court has already rejected this federal government's theory. United States versus California, a federal contractor managed oil drilling operations on behalf of the federal government. California imposed taxes on the contractor, which the contractor paid under protest with funds provided by the federal government. The federal government then filed suit in California, arguing it was entitled to recovery based on federal common law causes of action for money it had received. The Supreme Court unanimously rejected. The government cannot use the existence of obligation to indemnify to create a federal cause of action for money it had and received to recover state taxes. The federal government acknowledges that in past cases where courts have held mere fact that federal rights are being violated do not necessarily authorize the United States to sue. It attempts to distinguish on the ground the Heartbeat Act thwarts ordinary mechanisms of review through a congressionally conferred cause of action. But the statute does not thwart judicial review. It not only allows but requires pre-enforcement judicial review in state court. And a losing litigant can seek review by the United States Supreme Court. There's nothing unique about circumstances here. State tort law is often enforced by private parties in state courts with appeal to U.S. Supreme Court. Indeed, the Texas Heartbeat Act is not even the only state law to create a private cause of action the Fifth Circuit has considered in the last 20 years. In any event, even if these were unique circumstances, it would not justify creation of a new equitable cause of action. That's true. The Supreme Court traditionally cautious approach to equity leaves any substantial expansion of past practice to Congress. Yeah. Federal government's proposal to create a new equitable cause of action will not only violate the law, but the Supreme Court's post-Bivens precedent. When a plaintiff argues traditional equitable powers do not give sufficient necessary protection and damages remedy is necessary, the Supreme Court considers a number of economic factors. The same concerns counsel against creation of new equitable causes beyond traditional equitable powers. The federal government further suggests it must have a cause of action because equity suffers not a right to be without remedy. Moreover, the federal government is in no position to make this argument in light of its success. Persuading the Supreme Court rights often do not have remedies. For example, the Supreme Court has declined to create a Bivens cause of action even where there be no remedy whatsoever for particular claims. Notably, the federal government does not rely on equitable causes of action that allow federal courts to grant injunctive relief against state officers who are violating or plan to violate the federal law. Even where no one is arguing state immunity, the second of Ex Parte Young's holdings is relevant to the equitable action. Ex Parte Young cannot be brought against Texas. It must be brought against a state officer enforcing the law, not the state itself. Here, the federal government has not sued a state official at all, much less one with sufficient connection with enforcement of the alleged law. Yeah, this is pretty good stuff here. We're learning a lot on standing, by the way. I hope everyone is sort of appreciating how much we're learning on standing, because this is really great stuff. We're learning a lot about federal government standing issues and its limitations, and shows that standing is an issue the courts do take seriously, and take seriously even when it's the U.S. government. So these arguments are all lucid. You know, the district court is apparently eventually going to disagree with all this, and I look forward to finding out why when we get there. But these arguments are lucid, well argued, they make logical sense. They're good. Likewise, although equity sometimes provides a cause of action that enables potential legal defendants to assert their defenses preemptively, federal government does not and cannot invoke that proposition here. The federal government is not a potential defendant to the suit. Yeah. Nor has the federal government asserted defense by suing a would-be state court plaintiff. Instead, it sued Texas itself. Sovereign immunity aside, as equitable causes of action for an anti-suit injunction against Texas does not make any sense, because Texas could not institute a heartbeat suit against anyone, much less the federal government. No enforcement power means no enforcement power. Yeah. None of the cases that federal government cites support a cause of action. Federal government relies on DEBS, but as explained above, the cite portion were about whether the federal government had standing, not about whether it had a cause of action. DEBS did not extensively analyze the federal government's cause of action because the Supreme Court was considering a petition for habeas corpus, not an appeal from an underlying injunction, but was the well-known equitable cause of action to abate a public nuisance. The obstruction of a highway is a public nuisance. Public nuisance has always been subject to abatement at the insistence of the government. Since long before DEBS, it has been settled that a court of equity may take jurisdiction in cases of public nuisance by information, which is another way of saying a lawsuit, basically, by the Attorney General. The crux of the decision was the government may invoke judicial power to abate what is in effect a nuisance detrimental to the public interest. The cause of action to abate the nuisance, however, is no help to the federal government. The Texas Heartbeat Act simply creates a private cause of action. That is not a public nuisance, and the federal government does not argue otherwise. Moreover, even if Debs had created a cause of action, it could not apply where there is no factor of interstate commerce. When there's no basis on which to claim interstate commerce was obscured by denial of civil rights in violation of some congressional enactment, four courts have held judicial government lacks non-statutory authority to sue. In this case, the federal government does not bring a Commerce Clause claim, nor does it cite any actual evidence that it burdens interstate commerce. Yeah, this is a very weird burdening, and I'm not sure it's ever really applied before in this way. Because even in dormant Commerce Clause cases, it's like it creates problems where the state is interfering with another state, but that's not really what's happening here. So, yeah, it's yeah. The federal government also cites Winenville, but the case was also about implied cause of actions found in sub-state statutes. Because the federal government does not claim a statutory cause of action here, this is irrelevant. In any event, the unrefined analysis employed by this is no longer an accurate statement of law. In the middle of the 20th century, the court followed a different approach to recognizing implied causes of actions. Next, the federal government relies on United States versus City of Jackson, but it fails to cite the opinion on rehearing, in which two members of the original three-judge panel partially withdrew their concurrence. Depriving the original opinion of a majority, those two judges specified the federal government had ample statutory authorization for means of the suit and therefore did not reach the question of whether the United States would have standing to sue under the Commerce Clause absent enactment from Congress. Congress has displaced any cause of action. Finally, even if a cause of action could be inferred, Congress has displaced it by enacting a detailed remedial scheme for enforcement of the 14th Amendment right that does not include this kind of suit. That's, I don't know. That I'm not really buying that necessarily. It might work, but it's a little bit tough. When Congress gives power, it doesn't necessarily imply the lack of power somewhere else, necessarily, right? It'd be the equivalent of me saying, here's a whole list of things you can do. It doesn't necessarily make the list exhaustive. So, these are three express refusals of modern congressional to get the executive general injunctive power, which not only demonstrates explicit congressional intent not to create power, but also reveals an understanding unanimously shared by members of Congress and the Attorney General that no such power exists. This court should not attempt to override congressional policy, denying federal government broad authority to initiate action. So they're looking at laws that Congress did not pass, which is slightly dangerous in terms of trying to understand what Congress did pass. What Congress did not pass is not really super informative, really, to what Congress did pass. Section 1933, for example, creates a private 1983, for example, creates a private cause of action for private individuals to sue local governments as well as local and state government for vindications of federal rights. Congress provided an analogous criminal statute empowering the federal government to bring a criminal prosecution. But Congress has failed to provide a similarly broad civil cause of action for the federal government. Fair. Congress has given, the only thing Congress has not done is given the Attorney General a cause of action to enforce constitutional abortion rights, let alone against states. The omission viewed in light detailed remedial schemes Congress has enacted prevents the federal government from suing. Yeah, again, you don't need to really do that. It's not, you could just stop at it's not there, which would be perfectly fine, right? Private citizens have the right to sue for violations of their private rights against state actors. The federal government has the right to sue for violations of the criminal law. The federal government does not have any power to sue civilly under any statute. This whole negative implication thing is really not necessary to get you where you need to be at all, but okay. The more limited options Congress has provided for enforcing constitutional rights, and abortion rights in particular, demonstrates the federal government cannot have a cause of action here. The federal government's response is it must be allowed to bring suit because private individuals face hurdles. But Congress has anticipated this issue. In other cases, Congress has authorized the Attorney General to institute for or in the name of the United States a civil action when private individuals are unable, in the Attorney General's judgment, to initiate and maintain the proceedings, but it did not actually do so here. It didn't actually cite that authority. Fine. For decades, the Supreme Court has recognized Congress as perfectly competent, and we use that in a legal sense of the word, to authorize the United States to be the guardian of a public interest in a suit. But Congress has not authorized this. If the Department of Justice wants to expand its authority, it should direct its request to Congress, not the court. Okay. I need a very, very brief break. I'll be right back. The federal government contends the Texas heartbeat bill is per se unconstitutional because it bans abortion before a fetus is viable. That does not ban all pre-viability abortions. It sensibly regulates abortion consistent with the Constitution and Planned Parenthood versus Casey. Under Casey, states cannot enforce a prohibition of abortion or a substantial obstacle to the woman's effective right to elect the procedure before viability, while the court treats a legislative ban on non-therapeutic abortions before viability as per se unconstitutional. Mere obstacles are evaluated under undue burden. A finding of undue burden is shorthand for the conclusion state regulation has the purpose or effect of placing substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. The federal government argues for skipping undue burden analysis because the heartbeat is a ban, not an obstacle. But Texas is not banned pre-viability abortion. Instead, Texas has enacted a private cause of action to encourage, insofar as possible, that any abortions take place before heartbeat, which, as Mama Dr. Jones pointed out, is pretty impossible as a practical matter. Pre-viability abortions remain an option, most obviously before heartbeat. Moreover, the act does not prohibit pregnant women from receiving abortions, and it lifts regulations of third parties to the extent necessary to prevent undue burden. Yeah, so that's really funny because it's like it has to be litigated on a case-by-case basis, right? So Texas basically makes undue burden a defense, right? It makes a defense, but you still have to show it on a case-by-case basis. So it's like you don't know exactly what that is necessarily going in. By its own terms, then, the Texas channels abortions to pre-heartbeat time periods, except doing so where it would create an undue burden. Very technically correct, which is why the law is technically clever. Shifting the time at which some abortions occur is not a ban. Finally, the Heartbeat Act is not tied to a specific gestational age. It's not. The law, some people, they call it 6-week ban, but it's not a 6-week ban. It's a heartbeat ban. The law prevents some abortions from occurring, even pre-viability. Does not make it a ban. In Gonzalez, the Supreme Court considered a statute prohibiting partial birth abortions, both free viability and post-viability. The statute's necessary effect was to cause some women to carry their infant to full term, thus reducing absolute number of abortions. Still, the Supreme Court analyzed and upheld the statute under undue burden test, not as a per se rule against bans. And similarly, the Supreme Court applied the undue burden test to a law that would leave thousands of Louisiana women with no practical means of obtaining a safe legal abortion. Preventing some viability abortions not enough to turn the statute from a regulation into a ban. This is where Texas's creativity really shines in terms of the drafting of the law, right? Their creativity shine in the standing stuff too, so I don't want to make a mistake here, but this is where the statute shines in its creativity. So, good stuff. Under the undue burden test, the federal government claims fares no better. The Texas Heartbeat Bill incorporates the Supreme Court's test. Its statutory undue burden defense is modeled on the test Casey has. Very technically, yes. Even as everyone is adjusting to the new law, women have been able to obtain post-heartbeat bans or abortions. Dr. Alan Braid, for example, reports at least one of his patients received an abortion beyond the new legal limit, though he did not indicate whether it was pursuant to undue burden exception. That would be the guy who said, "Come at me, bro." Other pregnant women have received post-heartbeat abortions by traveling across state lines, which is not going to be sufficient, incidentally. According to the federal government, these options will increase over time as out-of-state abortion providers work hard to expand their capacity and increase the number of patients they can serve. The federal government points to abortion providers' fear of liability. Liability they believe is unconstitutional. Thus, the federal government would have the court believe the Texas Heartbeat Bill is facially unconstitutional, and the abortion providers no longer perform post-heartbeat abortions due to a reasonable fear of liability under the Act. Both cannot be true. Whenever imposing liability under the Act would be unconstitutional, courts would not do so. Neither litigants nor this court should assume Texas courts would be unwilling to apply the Supreme Court precedent. The federal government complains the statutory undue burden defense does not match the Supreme Court's undue burden standard in all relevant details, but that is relevant. Texas courts accept constitutional as well as statutory defenses, so if in any particular case the Constitution requires a broader defense than the statute provides, state courts will be readily able to accept that argument. That's perfectly fair, right? I mean, that's right. I mean, the statute can't ban a constitutional defense. Yeah. But at this point, there's no way to know whether any alleged differences between the defenses will ever arise, much less be material. Finally, the federal government half-heartedly suggests one last Mears theory. Texas appears to have acted with the purpose of infringing women's rights. Proof of any unlawful motive must appear on the record, yet the federal government cites no evidence of that Texas legislative purpose. The court cannot assume unconstitutional legislative intent, even where the statute produces no harms. Now, please take note what they're saying here very, very carefully. Very carefully. They're saying the law doesn't have any ill intent. And you might be able to point to some legislatures who said some things that might suggest they have an ill intent. But that's not the same thing as the law itself having ill intent, right? Especially to like a conservative and an originalist, right? Because random speeches or random comments from legislatures, even if they're the proponents of the bill, even if they're like the chairman of the committee that marks up the bill, even if they're Speaker of the House, even if they're whatever, like these random comments do not speak for the legislature as a whole, because all these comments are coming from a person or people, but not the legislature. So you can't really say what the motive of the legislature is. You can say what the motive of these people was, but what's the motive of the legislature? Well, you don't know. That's perfectly valid from an originalist perspective. It's like, you know, I mean, what's in one person's heart? Who knows what's in the other people's hearts, right? Notably, the federal government makes no attempt to show that many of the Act's other provisions create undue burden. The requirement that a doctor first attempt to detect a heartbeat resembles Texas's pre-existing requirement that physicians make unborn child's heart sound available prior to abortion. The federal government offers no evidence this creates an undue burden. Likewise, the federal government provides no evidence or argument that it acts fee-shifting provisions to challenge the law, or the requirement physicians make and keep certain records when performed imposes an undue burden. Yeah, keeping records is not an undue burden. I mean, the states regulate what kind of records physicians have to keep all the time. That's fine. At the bottom, the federal government's complaint is the Heartbeat Act is difficult to enjoin, but there's no requirement that state writes its laws to make them easily enjoined, which is kind of the whole reason we wrote them the way we did. Indeed, any state private cause of action would fail under this theory. This case is cited by the federal government confirm only states may not oust federal claims from their courts or place restrictions on them. They cannot be heard. State courts are open to hear constitutional challenges, and if federal subject matter jurisdiction can be found, so are the federal courts. Fine. Federal government has not shown the act is preempted or violates intergovernmental immunity. The federal government raises an as-applied preemption in intergovernmental immunity claims, but has not shown a violation of either doctrine. To create a conflict where none exists, the federal government overstates the act reach and its operation. Conflict exists when compliance with both state and federal law is impossible, or state law stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. The inquiry begins with the presumption a federal statute do not supersede states' historical police powers unless Congress clearly says so. So the states have the power to do stuff unless the federal law says clearly otherwise, because all powers are reserved to the states in the first instance. Preemption requires more than tension, but rather sharp conflict between the law. Federal law does not preempt state law under obstacle preemption analysis unless it's repugnant or a conflict is so direct and positive the two acts cannot be reconciled or constitutionally stand together. We try to avoid this when we can. Intergovernmental immunity prohibits state laws that regulate the United States directly or discriminate against the federal government or on those who it deals. Generally applicable laws do not run afoul of intergovernmental immunity, even if they result in an increased burden on federal contractors. Yeah, if the nature of the burden on the federal government is the state government not doing things, that is not a violation of the Constitution. It's a violation if the state does stuff. It's not a violation if the state doesn't do stuff or stops doing stuff. The state government is not required to help. They're just not. They are not allowed to impede. A state violates governmental immunity if they interfere with the federal contractor's ability to discharge the obligations consistent with terms set out by the federal government. The federal government's first theory is that the Heartbeat Act purports to prohibit federal personnel and contractors from carrying out their federal obligations, but the law does no such things. As an initial matter, Texas courts are unlikely to interpret the act to apply to the federal government or those carrying out federal obligations. True that. They would be in a lot of problem if they did. The Texas courts would be in a big problem if they said the law applies to federal government agencies or officials. No. Texas statutes generally include an implied exemption in favor of the United States and are held inapplicable to the United States. Yeah. The same presumption applies in favor of federal contractors when they act under the direction of the United States. That particularly is likely here because the Heartbeat Act creates a private cause of action only against certain persons. In the absence of express statutory definition, courts often apply long-standing interpretive presumption that person does not include the sovereign, and thus excludes a federal agency. Federal agencies are not people. That is true. This is doubly so in light of the federal government's constitutional objections. Texas courts interpret statutes in manner to avoid constitutional infirmities where possible. That is always true. Not only Texas courts, all courts. Yeah, all courts try to interpret laws in a way to avoid constitutional conflicts. So they will go out of their way, and sometimes very out of their way, to interpret a statute in a way to make it consistent with the Constitution. So they try to avoid it wherever possible. The court cannot assume the Heartbeat Act applies to federal government and its contractors. The federal government's motion does not acknowledge the existence of canon of construction, much less discuss the applicability. To the extent the federal government thinks Texas is misinterpreting the statute, the court should abstain in favor of a Texas court. The Pullman case establishes two prerequisites for Pullman abstention. There must be an unsettled issue of state law, and there must be the possibility the state law determination will be moot or present in a different posture than the federal questions raise. Both are present here. There's more than a possibility the state court will rule the act does not apply to the federal government, yeah, or those working for it, including contractors, which would be moot, or at least a different posture. I agree. There's no way on this earth any sane Texas judge would rule against a federal employee or a federal contractor in the carrying out of their federal duties. That is just a non-starter legally. Even if the heartbeat bill reaches the federal government, it does not interfere with those activities. As to the Bureau of Prisons, the Bureau of Prisons does not arrange for abortions that violate Texas's Heartbeat Act. While federal, this is going to be very, very technically correct, I can already tell. While federal regulations require a warden to arrange for an abortion should an inmate choose to abort the child, the warden is also required to ensure compliance with applicable law regarding this matter. The Bureau of Prisons guidance explains, staff should abide by federal and state, the state in which the institution is located, laws and regulations. There is no conflict between federal regulations and state law. The federal regulations expressly incorporate state law, including the Heartbeat Act. Clever. I don't think it's right, but it's very, very clever. By declining to violate state laws, federal officials do not violate anyone's constitutional rights. I mean, that's true. That's true because the federal government, they might violate some other kinds of rights, but they wouldn't violate constitutional rights because the federal government isn't required to do anything under the Constitution with regards to people. The entire Constitution is all things government should not do when it comes to rights, right? The federal government can't really violate anyone's rights by not doing things. That's kind of true. So yeah, good one. By declining to violate state laws, federal officials do not violate constitutional rights. Yeah. Bureau of Prisons warn pregnant inmates that laws related to termination of pregnancies vary among states. The mere fact of a mother's incarceration does not exempt the abortion from state regulation. Under some other law, on Marshal Service, according to the federal government, women in custody of the Marshal Service may elect to have an abortion under agent policy directives. Yet the federal government maintains amidst a key qualification that it has to be consistent with state law. Department of Defense. The federal government provides no evidence of DoD activities. It simply cites two federal statutes, neither of which require the DoD to provide abortions at all. A statute generally entitling service members to medical and dental care does not prove the DoD provides abortions, nor is the statute prohibiting federal funding for most abortions. There's no evidence the DoD provides abortions, much less that it somehow does so in a manner consistent with the Heartbeat Act. The Office of Refugee Resettlement. The federal government mischaracterizes the ORR's role. Out-of-circuit precedent requires only the federal government step out of the way when an alien in custody wants an abortion. Although the government not may place obstacles in the path of a woman's exercise of freedom, it need not remove those obstacles not of its own creation. So again, it can't stand in the way, but it doesn't have to help. Nothing requires the ORR to ensure that aliens are not obstructed by the state regulation. On the contrary, ORR practice is to treat state law deadline for abortion as an independent obstacle that is not of its own creation, which that's definitely true. ORR has announced its acts in alignments with state law governing the conduct of medical providers who provide abortions to minors. ORR requires its care providers to comply with state law governing access. ORR notifies a pregnant minor that they have right to decide whether to continue the pregnancy and give birth or have a legal abortion. There's no conflict. This might be very, very, very technically correct, and you got to admire Texas for really, holding on to that line. The federal government's second theory is the Heartbeat Act interferes with federal directives to third-party providers who are contractually obligated. Department of Labor. The federal government argues that Job Corps contractors will provide abortion services in a way that violates the Heartbeat Act. But the federal government's own handbook explains all center health staff and providers must follow accepted professional standards of care and are subject to prevailing state laws. There's no conflict. Even if the law were otherwise, the problem would be entirely hypothetical. The 4 Job Corps centers in Texas encounter very few pregnant students and incur no costs related to abortion. At the Job Corps Center in El Paso, there were only 3 pregnant students. None of them opted to terminate a pregnancy. The Laredo Job Corps had 0 pregnant students. None of them terminated their pregnancy, which would be hard for the 0, right? The Job Corps in San Marco does not have knowledge of how many students opted to terminate pregnancy, which itself demonstrates that students seeking abortions do not impose costs. The North Texas Job Corps had 12 pregnant students over 3 years, and only 1 or 2 saw an abortion. The contractor clarified, however, it does not incur cost of students who choose to have an abortion, as it did not transport the students. Office of Personnel Management. Even the federal government does not contend there's a conflict that will arise between OPM's health insurance contracts and the Heartbeat Act. The most it says that a conflict may arise. The federal government's declaration discusses only what could happen and how companies may respond. Speculation. Yeah, the federal government seemingly is not even asked carriers what they're doing. Regardless, a conflict will not arise because the state substantive regulations operate in a different space than federal covered decisions do. When a medical procedure does not occur because the state substantive law prohibits it, issues to whether the procedure would be covered is irrelevant. You know, we're not banning you on covering it. It's covered. Sure. We're just not going to do it. California has prohibited mental health providers from engaging in sexual orientation changes efforts with a patient under the age of 18. But no one contends the federal health plan covering such a service would override the state's substantive regulation. I didn't know California had done that, and thank God. Oh, no, sexual orientation. I'm sorry, I misread that. That's dealing with, that's not dealing with transgender issues. That's dealing with gay conversion therapy. Yeah, I knew California did that. So yeah, patients under 18, the mental health providers cannot try to make the kids not gay. That's illegal. Federal government's final theory is that it violates statutory and regulatory provisions consistent with Medicare, but Medicaid does not create a conflict for the same reason other health insurance plans do not. The fact that the federal program would provide funding to cover it if it occurred does not conflict with the fact that it's not provided. I mean, yeah, that's fair enough, I guess. The federal government cites Hope Medical Group, but this case is doubly irrelevant. First, the case considers a law restricting funding under Louisiana state Medicare program, not a general applicable regulation of the practice of medicine. Second, the court held that Louisiana law was invalid because it categorically prohibits funding for abortions in cases of rape or incest. The Texas Heartbeat Act is not so categorical. It creates an exemption if a physician believes medical emergency exists or if it otherwise would impose an undue burden. Man, whoever dreamed this up for Texas, man, and the lawyers who are writing this, definitely you're getting your money's worth out of this, man. You're definitely getting your money's worth. This is excellently well written. It's better written, in my humble opinion. Not to say that the U.S.'s complaint was bad. It was fine. It was a good complaint. It was well written. But this is even better written. This is even better written, in my opinion. That's also not to say, incidentally, that the U.S. government isn't right. To say the quality of writing or to say the quality of the argument isn't necessarily to say which is better, which is more legally correct. We've seen that happen before, incidentally. But it is to say, man, this is very well written. It's not patronizing. It's not insulting. It's not diminishing. It's in some ways very calm. It's not hysterical. It's just very calm and very methodical. It's not repetitive, which is a problem I have a problem with, and so do other complaints we've read. It's just, this is pretty damn good. This drafting is pretty damn good. It's like, Texas, you're making a lot of points here. It sounds pretty good. It sounds a lot better than what the U.S. government was arguing. But, the district court apparently ultimately disagreed, but then the Fifth Circuit disagreed with them. So I guess as we read on, we'll figure out if, one or the other is more persuading. But at the moment, I've got to give the points to Texas. Texas is kicking ass over here. The federal government wrongly assumes enforcement of the state law that violates the Constitution always cause irreparable harm. That is not true. It's not sufficient to argue there have been some violation of the Constitution, a plaintiff must allege a personal violation of the rights. Harm is irreparable. The federal government has previously made the same point as defendant, which I'm sure they have. Now the federal government relies on New Orleans Public Service versus City Council of New Orleans, but that case did not consider whether it was irreparable harm, even on the federal government's telling. It merely assumed irreparable injury in circumstances that were not present. In reality, the case only describes whether obviously unconstitutional statutes may possibly or perhaps establish irreparable injury in the context of whether a federal court should abstain, not grant a preliminary injunction. And here, if the text, even if the heartbeat defendant's injury somehow flowed through the federal government, irreparable harm could only occur if the threat of litigation chills the exercise of their rights, or a heartbeat defense have to pay unconstitutional judgments, but neither harm can support injunctive relief. Preliminary injunction cannot redress the first, and state court litigation is an adequate remedy at law for the second. And then they go into the fact that preliminary injunctions would not eliminate the possibility of future liability under the way SB 8 is written, which we can skip that analysis. They have adequate remedy at law for any liability determined. Abortion providers who are not chilled cannot be irreparably harmed. As an initial matter, the federal government seems to disclaim this theory. It argues that abortion providers in Texas ceased providing abortions after 6 weeks, absent a medical emergency. If the federal government is right, then no abortion providers will face heartbeat suits at all, much less face irreparable injury. That is the stupid argument. That is a stupid argument from Texas. They were doing really, really well, and they made a really, really stupid argument. They said, okay, abortion providers who are not chilled can't seek relief. All these abortion providers have voluntarily stopped providing abortions, so hey, none of them are impacted. In Texas, you were doing so well, and it was like, no, this is what chilling looks like. The fact that they've discontinued their conduct is kind of exactly what chilling looks like. You kind of hoisted yourself on your own petard there, my friend. Nice try on that one, though. The federal government also seems to suggest third parties will suffer irreparable harm if and when they find them liable. If that were so, it would not harm the federal government. True. It's not your harm. I mean, that's fair. Any third party would have adequate remedy at law, raising any relevant defense, including constitutional defense. Federal courts cannot grant injunctive relief unless the remedies at law are inadequate. Which is fine, because this is also a very nice reminder that injunctions are not they're not strictly speaking legal, they're equitable, right? So yeah, if you have adequate remedy at law, injunctions should not issue because you have adequate remedy at law. And they're like, yeah, so you shouldn't be able to get an injunction because, you have adequate remedies. You can raise all the defenses you want. And if you're right, you're fine. This rule applies with special force when the plaintiff asks federal court to enjoin threatened litigation. Injunction against threatened litigation will not issue if a party has adequate opportunity to fully present defenses in legal action they seek to enjoin. Judge Posner, who is badass, wrote, if A knows that B is about to sue him and thinks that B's suit is barred, A cannot file suit against B asking B be enjoined on the grounds that they have a good defense. The reason that the case give for this result is that A has an adequate remedy at law to interpose the defense in the case brought by an adequate and lax remedy law is a prerequisite to obtain relief. So yeah, if you know that you're about to be sued, you can't enjoin them from suing you. You can sue them first, but you can't enjoin them from suing you. And incidentally, the way you would sue them first is by Declaratory Judgment Act case is how you would do that. So you wouldn't seek an injunction, you'd say, I want declaratory relief, that I'm right. And once you have specific enough notice, you have standing. To the extent the federal government is interested in any case, it's free to intervene and challenge the constitutionality of that act. So, yeah, if the federal government really is concerned about how this impacts its citizens, it can always, intervene or write an amicus and stuff. It can get involved. Because the federal government can intervene in state court proceedings, is adequate remedies at law that preclude the relief. The federal government cannot credibly argue the ability to raise a constitutional defense is not adequate remedy. It routinely takes the position Texas has here, including just 5 months ago, when Ohio challenged a federal statute it claimed irreparable harm from potential proceedings the federal government could initiate. Urging the court to deny preliminary relief, the DOJ argued an injunction against even threatened action will not issue if a party has adequate opportunity to fully present defenses and objections in a legal action he's seeking to enjoin. And then they're going to argue the equitable factors a little more explicitly, and that's the end of the case, or the end of the argument. So, good stuff, man. Good stuff. Texas, who wrote this, so we can give appropriate credit, or who signed off on it at least. Apparently, William Thompson, who apparently is the deputy chief for the special litigation unit. Looks like it's his work. So, kudos to William Thompson. Kudos to William Thompson, who, as a lawyer, is kicking all of our asses, including the DOJ's ass, in terms of writing a good thing. He raises some really good arguments, and he does them in a very good way. It's very clean and it's not boring. It's not repetitive. It's interesting. It's logical. Some of it's hyper-technical, but, still in a way that kind of works. So this was great. This is great. So based on because I always give my assessment of these things, right? So based on this, I would think Texas has the better end of the argument. Texas seems like they had the better ending of the standing argument. Seems like the United States has some standing problems. And it also seems like there's no harm to any federal government agency or employee. And Texas, and they didn't even really go with the whole severance thing. They didn't even make the severance argument, which is even more creative, because that's like where my mind immediately goes, is to the severance argument. But they didn't even raise that issue, which is kind of baller and cool. So really, really good stuff. Really, really good stuff. Noli says, I made it interesting and awesome. Thank you. And thank you, Law Nerd Clips, from also saying so. I'm glad. I try to make it interesting. I try to make the analysis interesting. I always try to be fair to both sides, try to give my best legal analysis, and note where things disagree. And as I noted, the district court apparently thought otherwise, and the Fifth Circuit apparently disagreed with the district court. We don't know what the reasoning is yet, but Texas is like, it's like, damn son, you really making the U.S. government work on this one. Looks pretty good. Looks pretty convincing. All right, so let me take some of your questions from the bot. Drew Black says, what is your favorite weird law? Well, I kind of liked Nix versus United States on the debate over whether a tomato is a vegetable or a fruit. I kind of like that one. That was. I don't know if that's a weird law. It's something a legislature passed. I don't know. Nothing comes immediately to mind. Joe's Med says, since the DOJ thinks it's good to sue states for violating constitutional rights, can we assume it's about to sue New York and California for violating gun rights? Yeah, that's what if wishing made it so, Joes, if wishing made it so. Like, yeah, I've said that last time. I think I said it a couple times last time. Anytime the U.S. government wants to start, suing states for violating the Second Amendment, let me know. Stephanie asked, did they define viability? No, and they can't by law. There's case law on that. They can't define viability explicitly. So no. But it doesn't, no. At least they can't define it in terms of a number of weeks. I'm not sure they can define it by any criteria in particular. I'd have to double check the law though. Matt says, federalism, the one way the average person gets confused when it comes to state federal law. Federalism is hard. It's legally hard. Yeah. Stella asks, can Texas secede to moot a federal lawsuit? Texas can't secede according to the U.S. Supreme Court. There was a case on it. Matt says, since they're all in the same posture, does a class action law potentially apply? As defendants? I'm not sure I've ever seen that before, where you sue defendants as a class. The plaintiffs are usually the class, not the defendants. I'm not sure I've ever seen a situation where you have defendants as a class. Interesting idea, though. I'm not sure if that would work or not. Matt says, what would happen if a state court went off the reservation just started issuing decisions violating the federal constitution? What can be done outside a federal lawsuit? Well, they can be impeached. They can be overruled. They can be impeached. That's about the list of things. Yeah, so if a state just goes off the reservation and just starts, or they can be not elected or not appointed, as the case may be, because state judges don't serve for life. So, yeah, they can be removed from the bench or they can be reversed. That would be what would be required if they went off the reservation. So that's the list of things that are possible. Joe says, it's hilarious how Texas brings up the federal government's own arguments in light of Bivens. That was pretty cool, I have to admit, too. Drew says, are you aware of any other clever laws? I'm aware of laws that are kind of clever in parts, or clever in aspects of it. But this law is clever in its totality. Like, you can have little clever moments in law, but I'm not aware of any law that's as complex as this that is clever in its totality. Or clever in sort of one. Clever in like an aspect here, or clever in an aspect here, or doing something interesting. But this entire thing is really clever in totality. I'm not really aware of any law off the top of my head which is comparable in that way. Nozako says, are you aware that Nick is still a lightweight who drank you under the table? He didn't. And that Joe caused he puked live on stream. And Joe lost because he puked live on stream. Yeah, Nick didn't drink me under the table. No. Joe said, I think you might be right regarding Bureau of Prisons, but counter-argument. Can the federal government be required to do stuff for people in its own custody, even if they wouldn't otherwise? All governments are only required to do stuff in so much as the statute or Constitution requires. The U.S. government is not required to do anything that the statute or the Constitution doesn't require them to do. So, can the federal government be required to do stuff? If Congress says they are, if Congress passed a law saying they are, then yeah. Otherwise, no. MK Perez says, now go and fight Joe. Lol. Yeah, I'm not sure that's a great idea for many, many reasons, but yeah. I'm not sure it's a good idea at all. Yeah. Would I ever consider becoming a judge? I'd love becoming a judge. please let Biden know that I am available at any time to be a federal judge. I'd be a good federal judge, I think. Yeah. All right, so I'm going to sign off. Oof. If you've enjoyed this stream, please remember to give it a like. If you're not subscribed already, please remember to subscribe. And did you know for 99 cents, you too can become a uncivilian? It's true. Please hit the join button or hit the link that Streamlabs is telling you about periodically, and hope you enjoy us for more legal education content. I've been on Civil Law. Until later, my friends, cheers and goodbye.